The state executive of the Indian Constitution is composed of the following three members. Governor. The governor is the nominal head of the state and is appointed by the President of India for a term of 5 years. The governor has a number of powers, including the power to appoint the chief minister and other ministers, dissolve the state legislature, veto laws passed by the legislature, issue ordinances. Chief Minister. The chief minister is the real executive head of the state and is appointed by the governor. The chief minister is the leader of the majority party in the state legislature. Council of Ministers. The Council of Ministers is a body of ministers appointed by the governor on the advice of the chief minister. The Council of Ministers is collectively responsible to the state legislature. In addition to these three members, the state executive also includes the Advocate General of the state. The Advocate General is the state's highest law officer and is appointed by the governor. The Advocate General provides legal advice to the state government and represents the state in court. The state executive is responsible for the administration of the state and for implementing the laws passed by the state legislature. The state executive also plays a role in national affairs, as it is required to cooperate with the union government in matters of national importance. Here is a table summarizing the powers and functions of the three members of the state executive. Member, powers and functions. Governor, appoints the chief minister and other ministers, dissolves the state legislature, vetoes laws passed by the legislature, issues ordinances. Chief Minister, leader of the majority party in the state legislature, appoints other ministers, directs the work of the state government. Council of Ministers, collectively responsible to the state legislature, formulates and implements state policies, exercises executive powers. Advocate General, provides legal advice to the state government, represents the state in court. I hope this helps. The governor is the constitutional head of a state in India. She is appointed by the President of India for a term of 5 years. The governor has a number of powers, but these are mostly exercised on the advice of the Chief Minister and the Council of Ministers. The main powers of the governor are to appoint the Chief Minister and other ministers, to dissolve the state legislature, to give assent to laws passed by the legislature, to reserve laws passed by the legislature for the consideration of the President, to promulgate ordinances when the legislature is not in session, to represent the state in the Supreme Court and the High Court, to appoint judges to the High Court and other high-level officials. The governor is also the commander-in-chief of the state's police and armed forces. However, she cannot use these powers without the consent of the president. The governor is supposed to be a neutral figure and should not interfere in the day-to-day working of the state government. However, in practice, the governor often has to play an active role in state politics, especially during times of political instability. Here are some of the important provisions of the Indian Constitution related to the governor. Article 153. There shall be a governor for each state. Article 154. The executive power of the state shall be vested in the governor and shall be exercised by him either directly or through officers subordinate to him in accordance with this constitution. Article 155. The governor of a state shall be appointed by the president by warrant under his hand and seal. Article 156. The governor shall hold office during the pleasure of the president. Article 157. No person shall be eligible for appointment as governor unless he is a citizen of India and has completed the age of 35 years. The governor is an important constitutional position in India. She plays a vital role in the smooth functioning of the state government. However, the governor's powers are limited and she is supposed to act as a neutral figure. The Chief Minister, CM, is the head of government of a state in India. The CM is appointed by the governor of the state on the advice of the majority party in the state legislature. The CM is the leader of the Council of Ministers, which is the body of ministers who help the CM run the state government. The CM's powers are derived from the Constitution of India. Article 163 of the Constitution states that the executive power of the state shall be vested in the governor and shall be exercised by him either directly or through officers subordinate to him. However, the governor can only exercise this power on the advice of the CM. This means that the CM is the real executive head of the state. The CM has a number of powers, including initiating legislation in the state legislature, appointing and dismissing ministers, controlling the state bureaucracy, formulating and implementing state policies, representing the state in the national government. The CM is also responsible for the day-to-day administration of the state. This includes ensuring that the laws of the state are implemented, that the state's finances are managed effectively, and that the needs of the people are met. The CM is elected to a 5-year term, but can be removed from office before the end of her term if the state legislature passes a vote of no confidence. The CM can also resign at any time. The CM is an important figure in Indian politics. She is responsible for the smooth running of the state government and for ensuring the welfare of the people. The CM is also a key player in national politics, as she represents the state in the union government. The State Cabinet of the Indian Constitution is a body of ministers headed by the Chief Minister. The Council of Ministers is collectively responsible to the state legislature. This means that the Council of Ministers must resign if the state legislature passes a vote of no confidence. The Council of Ministers is appointed by the Governor on the advice of the Chief Minister. The number of ministers in the Council of Ministers is not fixed, but it must not exceed 15% of the total number of members of the state legislature. The ministers in the Council of Ministers are drawn from the state legislature. They must be members of the legislature in order to be eligible for appointment as ministers. The Council of Ministers is responsible for the administration of the state. It is responsible for formulating and implementing state policies, and for overseeing the work of the state bureaucracy. The Council of Ministers meets regularly to discuss and decide on matters of state policy. The Chief Minister chairs the meetings of the Council of Ministers. The Council of Ministers is an important part of the state government. It is responsible for the day-to-day administration of the state and for ensuring that the needs of the people are met. The following are the important provisions of the Indian Constitution related to the State Cabinet. Article 163. There shall be a Council of Ministers with the Chief Minister at the head to aid and advise the Governor in the exercise of his functions, except in so far as he is by or under this Constitution required to exercise his functions or any of them in his discretion. Article 164. 1. The Chief Minister shall be appointed by the Governor and the other ministers shall be appointed by the Governor on the advice of the Chief Minister. 2. The Council of Ministers shall be collectively responsible to the Legislative Assembly of the state. 3. The Chief Minister shall be responsible for the general direction and control of the work of the Council of Ministers. The State Cabinet is an important part of the Indian government. It is responsible for the administration of the states and for ensuring that the needs of the people are met. The Vice President, VP, of India is the second highest constitutional office in the country, after the President. The VP is elected by the members of the Electoral College, which is composed of the members of both houses of Parliament and the elected members of the Legislative Assembly of each state. The VP is the ex officio chairman of the Rajya Sabha, the upper house of Parliament. The VP also discharges the functions of the President in certain circumstances, such as when the President is unable to discharge her functions due to illness or absence. The Vice President is not a member of the legislature. She cannot participate in the debates or vote on any matter that is being considered by the legislature. However, the VP can address the legislature on any matter of public importance. The legislature in India is bicameral, consisting of the Lok Sabha, House of the People, and the Rajya Sabha, Council of States. The Lok Sabha is the lower house and is directly elected by the people. The Rajya Sabha is the upper house and is indirectly elected by the members of the state legislatures. The legislature is responsible for making laws, approving the budget, and overseeing the work of the executive. The legislature also has the power to impeach the president and the vice president. The vice president and the legislature are two separate and independent bodies. The VP does not have any legislative powers. However, the VP plays an important role in the smooth functioning of the legislature. Here is a table summarizing the key differences between the Vice President and the legislature. Characteristic: Vice President, Legislature. Election: elected by the Electoral College, elected by the people, Lok Sabha, or the state legislatures, Rajya Sabha. Membership: not a member, member. Powers: no legislative powers, makes laws, approves the budget, and oversees the work of the executive. Role in the legislature: ex officio chairman of the Rajya Sabha, can address the legislature on any matter of public importance. I hope this helps. Let me know if you have any other questions. The Legislative Assembly, Vidhan Sabha, and the Legislative Council, Vidhan Parishad, are the two houses of the state legislature in India. The Legislative Assembly is the lower house and is directly elected by the people. The Legislative Council is the upper house and is indirectly elected by the members of the state legislature, local authorities, and other educational and professional institutions. The Legislative Assembly is the more powerful of the two houses. It has the power to make laws, approve the budget, and remove the government from power. The Legislative Council can only delay or reject laws passed by the Legislative Assembly, but it cannot make laws on its own. The Legislative Assembly is composed of members of the Legislative Assembly, MLAs, who are elected by the people of the state. The number of MLAs varies from state to state, but each state has at least 60 MLAs. The MLAs are elected for a term of 5 years. The Legislative Council is composed of members of the Legislative Council, MLCs, who are indirectly elected by the members of the state legislature, local authorities, and other educational and professional institutions. The number of MLCs varies from state to state, but each state has at least 40 MLCs. The MLCs are elected for a term of 6 years. The main functions of the Legislative Assembly are to make laws, to approve the budget, to remove the government from power, to oversee the work of the executive, to represent the interests of the people. The main functions of the Legislative Council are to delay or reject laws passed by the Legislative Assembly, to advise the government on matters of policy, to represent the interests of the different sections of society. The Legislative Assembly and the Legislative Council are important parts of the state government. They play a vital role in making laws, approving the budget, and overseeing the work of the executive. The two houses also represent the interests of the people and the different sections of society. Here is a table summarizing the key differences between the Legislative Assembly and the Legislative Council. Characteristic: Legislative Assembly, Legislative Council. Election: directly elected by the people, indirectly elected by the members of the state legislature, local authorities, and other educational and professional institutions. Power: more powerful, less powerful. Functions: makes laws, approves the budget, removes the government from power, oversees the work of the executive, represents the interests of the people, delays or rejects laws passed by the Legislative Assembly, advises the government on matters of policy, represents the interests of the different sections of society. I hope this helps. The Election Commission of India, ECI, is an autonomous constitutional body established by the Constitution of India to conduct and regulate elections in the country. Article 324 of the Constitution provides that the power of superintendence, direction, and control of elections to Parliament, state legislatures, the office of the President of India, and the office of Vice President of India shall be vested in the Election Commission. Thus, the Election Commission is an all-India body in the sense that it is common to both the central government and the state governments. The ECI is headed by the Chief Election Commissioner, CEC, who is assisted by 2 election commissioners. The CEC and the election commissioners are appointed by the President of India in consultation with the Chief Justice of India and the leaders of the major political parties. The ECI has a number of powers, including to make rules for the conduct of elections, to appoint election officials, to decide on the eligibility of candidates, to conduct elections, to declare the results of elections. The ECI is also responsible for ensuring that elections are free and fair. It does this by taking a number of measures, such as registering voters, Conducting random checks of electoral rolls. Using electronic voting machines, EVMs. Deploying security forces. The ECI is an important institution in Indian democracy. It plays a vital role in ensuring that elections are free and fair, and that the will of the people is expressed through the ballot box. Here are some of the important provisions of the Indian Constitution related to the Election Commission. Article 324. The superintendence, direction and control of elections to Parliament, to the legislature of every state and to the offices of President and Vice President shall be vested in a commission called the Election Commission. Article 325. The Election Commission shall consist of the Chief Election Commissioner and such number of other election commissioners as the President may from time to time fix. Article 326. The Chief Election Commissioner shall be appointed by the President in consultation with the Election Commission. Article 327. The other election commissioners shall be appointed by the President in consultation with the Chief Election Commissioner. Article 328. The Election Commission shall be a body corporate with perpetual succession and a common seal. The Election Commission is an independent body and is not subject to the control of any other authority. It is responsible for ensuring that elections are free and fair, and that the will of the people is expressed through the ballot box. Elections in India are conducted by the Election Commission of India, ECI, an independent constitutional body established by the Constitution of India. The ECI is responsible for the conduct of all elections to the Lok Sabha, House of the People, the Rajya Sabha, Council of States, the state legislative assemblies, and the offices of the President and Vice President of India. The ECI has a number of powers, including, to make rules for the conduct of elections, to appoint election officials, to decide on the eligibility of candidates, to conduct elections, to declare the results of elections. The ECI is also responsible for ensuring that elections are free and fair. It does this by taking a number of measures, such as registering voters, conducting random checks of electoral rolls, using electronic voting machines, EVMs, deploying security forces. The electoral process in India is based on the principle of universal adult suffrage. This means that all citizens of India who are 18 years of age and above are eligible to vote. The ECI is responsible for registering all eligible voters and issuing them with voter ID cards. Elections in India are held every 5 years for the Lok Sabha and every 6 years for the Rajya Sabha. The President and Vice President are elected by an electoral college consisting of members of Parliament and the state legislative assemblies. The ECI has been praised for its role in conducting free and fair elections in India. However, there have been some allegations of electoral fraud and irregularities. In recent years, the ECI has taken steps to address these concerns, such as introducing EVMs and deploying more security forces. The electoral process in India is a complex and challenging task. However, the ECI has made significant progress in ensuring that elections are free and fair. The ECI is an important institution in Indian democracy and plays a vital role in ensuring that the will of the people is expressed through the ballot box. Here are some of the key features of the electoral process in India. Universal adult suffrage. All citizens of India who are 18 years of age and above are eligible to vote. Secret ballot. Voters cast their votes in secret, ensuring that their vote is not influenced by anyone else. Free and fair elections. The ECI is responsible for ensuring that elections are free and fair, without any interference from the government or any other party. Electronic voting machines, EVMs. EVMs are used to record and count votes, ensuring that the process is transparent and accurate. Deployment of security forces. Security forces are deployed to ensure that elections are conducted in a peaceful and orderly manner. The electoral process in India is a vital part of the country's democracy. It ensures that the will of the people is expressed through the ballot box and that the government is accountable to the people. An amendment to the Constitution is a formal change to the Constitution. It can be made to change or clarify the meaning of the Constitution, or to add new provisions. The Constitution of India can be amended by the Parliament of India. An amendment bill can be introduced in either house of parliament. The bill must then be passed by a majority of the members present and voting in each house. After it is passed by both houses, it is presented to the president for his/her assent. The president cannot refuse to give assent to an amendment bill, unless it is inconsistent with the basic structure of the Constitution. There are three types of amendments to the Constitution of India. Simple majority amendments. These amendments can be passed by a simple majority of the members present and voting in each House of Parliament. Special majority amendments. These amendments require a special majority of the members present and voting in each House of Parliament, as well as ratification by at least half of the state legislatures. Constitutional amendments. These amendments are the most difficult to pass, as they require a two-thirds majority of the members present and voting in each House of Parliament, as well as ratification by at least two-thirds of the state legislatures. As of October 2021, there have been 105 amendments to the Constitution of India. The most recent amendment was the 104th Amendment, which was passed in 2019. This amendment introduced a number of changes to the electoral system, including the introduction of the "none of the above" option. The amendment process is a complex and time-consuming process. However, it is an important way to ensure that the Constitution can be adapted to changing needs and circumstances. The emergency provisions in the Indian Constitution are a set of special powers that can be invoked by the President of India in times of national emergency. These provisions are contained in Part 18 of the Constitution, from Article 352 to 360. The emergency provisions can be divided into three categories. National emergency. This is the most serious type of emergency and can be declared by the President if the security of India or any part of it is threatened by war, external aggression, or armed rebellion. President's rule. This type of emergency can be declared by the President if the government of a state cannot be carried on in accordance with the provisions of the Constitution. Financial emergency. This type of emergency can be declared by the President if the financial stability or credit of India is threatened. The emergency provisions give the President sweeping powers to deal with the situation. These powers include the power to suspend fundamental rights, proclaim central rule in a state, take control of the state's finances, make laws by ordinance. The emergency provisions have been invoked a number of times in India's history. The first national emergency was declared in 1962, during the Sino-Indian War. The second national emergency was declared in 1971, during the Bangladesh Liberation War. The third national emergency was declared in 1975, by Indira Gandhi, and lasted for 21 months. The emergency provisions have been controversial since their inception. Critics argue that they give the President too much power and can be used to suppress dissent. However, supporters argue that they are necessary to protect the country in times of crisis. The emergency provisions have been amended a number of times since they were first introduced. The most recent amendment was the 44th Amendment, which was passed in 1978. This amendment limited the President's powers to declare a national emergency and made it more difficult to do so. The emergency provisions are a powerful tool that can be used to deal with a national crisis. However, they should be used sparingly and with caution, as they can also be used to undermine democracy. There have been 105 amendments to the Constitution of India since it was adopted in 1950. Some of the most important amendments include: First Amendment. This amendment was passed in 1951 and gave Parliament the power to amend the fundamental rights. This amendment was necessary to allow Parliament to make changes to the fundamental rights in order to accommodate the needs of a developing country. Second Amendment. This amendment was passed in 1955 and inserted the 9th Schedule to the Constitution. The 9th Schedule lists certain laws that are immune from judicial review. This amendment was passed to protect land reform laws from being struck down by the courts. 17th Amendment. This amendment was passed in 1964 and increased the number of seats reserved for scheduled castes and scheduled tribes in the Lok Sabha and the state legislative assemblies. This amendment was passed to ensure that these communities have adequate representation in the legislature. 24th Amendment. This amendment was passed in 1971 and abolished the privy purse, which was a payment made to the former rulers of princely states. This amendment was passed to bring about social and economic equality in the country. 42nd Amendment. This amendment was passed in 1976 and gave Parliament the power to amend any part of the Constitution, including the fundamental rights. This amendment was passed by the Indira Gandhi government during the emergency and was seen as an attempt to consolidate her power. 44th Amendment. This amendment was passed in 1978 and restored the original provisions of the fundamental rights that had been amended by the 42nd Amendment. This amendment was passed after the emergency was lifted and was seen as a step towards restoring democracy in India. 86th Amendment. This amendment was passed in 2002 and lowered the voting age from 21 years to 18 years. This amendment was passed to give young people a greater say in the political process. 93rd Amendment. This amendment was passed in 2005 and introduced a number of changes to the electoral system, including the introduction of the nota, none of the above, option. This amendment was passed to make the electoral system more democratic and responsive to the needs of the people. These are just a few of the most important constitutional amendments in India. The Constitution is a living document that has been amended over time to reflect the changing needs and circumstances of the country. Here are some other important constitutional amendments in India. 61st Amendment. This amendment was passed in 1989 and extended the reservation of seats for scheduled castes and scheduled tribes in the Lok Sabha and the state legislative assemblies from 25 years to 70 years. 73rd Amendment. This amendment was passed in 1992 and introduced the Panchayati Raj system in India. The Panchayati Raj system is a system of local self-government that gives power to the people at the grassroots level. 74th Amendment. This amendment was passed in 1992 and introduced the Nagarpalika system in India. The Nagarpalika system is a system of urban self-government that gives power to the people in urban areas. 81st Amendment. This amendment was passed in 2000 and introduced the Right to Information Act in India. The Right to Information Act gives citizens the right to access information from the government. 97th Amendment. This amendment was passed in 2011 and introduced the Right to Education Act in India. The Right to Education Act guarantees free and compulsory education to all children between the ages of 6 and 14 years. 102nd Amendment. This amendment was passed in 2018 and introduced the Triple Talaq Act in India. The Triple Talaq Act makes it illegal for Muslim men to divorce their wives by uttering the word talaq 3 times. These are just a few of the other important constitutional amendments in India. The Constitution is a living document that has been amended over time to reflect the changing needs and circumstances of the country.